I am very pleased to be able to contribute some aspects of my research and teaching experience that seem important to me and which concern the transnational and universal dimension of constitutional law to this ELPIS book in honor of Professor Hilmar Fenge. I would like to express my highest appreciation of the fact that Professor Fenge has greatly promoted the Erasmus idea and, like me, has worked closely with the University of Lisbon, especially with my colleague and friend, Professor Vasco Pereira da Silva. It is all the more important for me to express my gratitude for this, as I myself am involved today in Erasmus teaching, especially in Paris, Rome, Spain, and Greece. I'm particularly interested in research and teaching in comparative constitutional law, and since my contribution is devoted to questions of teaching in particular, I would like to present some theses on the teaching of constitutional law today that seem important to me. It is common opinion that constitutional law can only be properly understood in an interdisciplinary way. Political, economic, sociological, historical, and cultural aspects and methodological approaches are indispensable. In my contribution, however, I would like to focus on 2 points that I believe play an important role for teaching. On the one hand, that constitutional law of today is constitutional law of the so-called open state, that we must not only consider the constitutional law of our own country, but also the influence from outside, from the international and especially supranational level, and also integrate the inspirations that arise from a comparative law perspective into the teaching of national constitutional law. On the other hand, however, we must also take into account that the genuine and only possible constitution, if it can really be called a constitution, is the liberal democratic constitution, which is oriented towards the human being, to use my terminology, which is anthropocentric, and which, because of this orientation towards the human being, is based on universal principles, which in their functional core are the same in all states with a genuine constitution. The fact that these principles are not always fully observed in political practice or are not observed at all is a reality, but does not escape the ideal typical statement. On the first point, I would like to say the following and start with the most intensive external influence on national constitutional law, the influence of EU law for EU member states. The national constitutional law of an EU member state is in various respects institutionally and functionally linked to the supranational law of the European Union. EU law has direct applicability in the legal systems of the member states. That is, it takes its place alongside national law. The German legal system, to take this example, consists of 2 parts that are in one and the same legal system, national and supranational law. The norms of the European Union primary law, which are functionally constitutional in character, are therefore also parts of constitutional law in Germany, even if they do not, because of their autonomy, transform themselves into German constitutional law. The European Union Charter of Fundamental Rights has effect for the German legal order. If the member states implement EU law, the Charter, according to its Article 51, applies and not national constitutional law. How this Article 51 of the Charter is to be interpreted is disputed between the Court of Justice of the European Union and the Federal Constitutional Court in Germany, and as we know, the positions converge and diverge to some extent. Special features apply to mixed situations in which EU law predetermines the normative framework but leaves it open to the member states to fill out this framework on certain points. This is the subject of the European Union General Data Protection Regulation, for example, which largely regulates the details of data protection, but leaves it up to the member states, for example, for the so-called media privilege, to go into more detail. In the opinion of the Federal Constitutional Court in Germany, German constitutional law, specifically German fundamental rights, which are applicable here, comprise the fundamental rights content of the European Union Charter of Fundamental Rights. The Federal Constitutional Court points out that in such cases, a presumption exists that the level of protection of the Charter of Fundamental Rights of the European Union is co-guaranteed by the application of the fundamental rights of the basic law of the German Constitution. There is thus a kind of functional fusion of national and supranational fundamental rights protection in this respect. It is also clear that the coexistence of national and supranational constitutional systems is increasingly leading to a functional harmonization. Thus, as the Federal Constitutional Court expresses on another occasion, German fundamental rights are also to be interpreted in the light of the EU Fundamental Rights Charter. Here, a process is taking place that already took place in 2004, from the beginning of 2004 on, with the well-known Gergely decision of the German Constitutional Court in relation to the European Convention on Human Rights. German fundamental rights are to be interpreted in a manner that is friendly to international and European law, regional international law, and European Union law are interpretation aids for the understanding of fundamental rights, which, however, lead to a strong convergence of interpretation. As it is generally known, the Federal Constitutional Court has established for Germany, and similar processes can be found in other EU member states, the national reserve of constitutional identity, which as a legal concept is oriented towards the so-called eternity clause, or we could also say perpetuity clause of Article 79, paragraph 3 of the Basic Law. This so-called eternity clause means that a formal reform of the Constitution cannot extend to human dignity, Article 1 of the Basic Law, or to the principles laid down in Article 20 of the Constitution, such as democracy, republic, social state, rule of law in its essential features, and the federal state. This limitation of constitutional reform also applies because of the reference to it made by the integration article, the European Union Article 23 of our Constitution, as a limit to the effect of supranational law on German legal order. For this reason, the application of the European Union Charter of Fundamental Rights was not applied from the outset when it came to the concept of human dignity, which was excluded from the scope of the application of EU law and thus also of the EU Charter of Fundamental Rights, because of Article 79, paragraph 3 of the Basic Law. However, a relativization process is also evident here, insofar as the Federal Constitutional Court also considers the Charter of Fundamental Rights of the EU to be applicable in the case of functional equivalence, independently from the above-mentioned eternity clause. Moreover, it should also be noted that the Federal Constitutional Court has now extended its criteria of review in constitutional complaints to the extent that it also reviews the violation of fundamental rights of the EU Charter of Fundamental Rights, and not only of the German fundamental rights, as it has been in a traditional way, if these have not been correctly weighed or interpreted by national courts. In all this, we see a strong linkage of national fundamental rights protection, that is the most important part of constitutional law, with the supranational legal order of the European Union, and also with the European Convention of Human Rights, which the German Federal Constitutional Court regards as a normative basis for both national and supranational fundamental rights protection. These findings of the constitutional link between national, supranational, and international legal orders are not only relevant for German constitutional law, but also for the constitutional law of the other European Union member states. In non-European Union member states, the supranational dimension is absent, but even here, cross-border interpretative references to international courts, and in some systems quite distinctly to other legal orders, are often visible. As far as fundamental rights are concerned, the general point of reference is the protection of the human being, for which there is a need at all levels of national and international levels. The judicial dialogue in this area crosses the borders of legal systems and introduces the solutions of other courts as advisory authorities. Comparative law can provide inspiration here, which is expressed in the interpretation of one's own fundamental rights. At least in the field, there is a clearly visible tendency towards this. All in all, we can speak of and I use now the French expression, bloc de constitutionnalité européen et international. This expression, bloc de constitutionnalité, has been used by the French Conseil constitutionnel when the court extended the application of French constitutional law to various sources, different in time and different in documents. And I want to transfer this expression also to the European situation of constitutional law and speak of a constitutional bloc which is European and international. Bloc de constitutionnalité européen et international. The consequence of noting this multi-layered nature of constitutional law is that academic teaching must incorporate this broader perspective from the outset. This applies in particular to the values part of the Constitution, that is, the fundamental rights, but also to the institutions. Thus, it is important to ask whether there is sufficient democratic legitimacy of public authority, be it of national or supranational origin, and how the two are related. In addition, there is a further question of the extent to which the national governance has to take supranational interests into account, the extent to which supranational concerns are included in the discretionary consideration of the executive, the extent to which national jurisdiction is linked to supranational jurisdictions, and many more questions. It is therefore essential to duly integrate the international and especially the supranational dimension of national constitutional law into the teaching. I would like to address a second topic in this context. As already noted above, a genuine liberal democratic constitution is based on certain principles, unchanging in their functional core, which are indispensable for the constitution and therefore also claim general, even universal validity. The starting point is the orientation of law in general, and especially of constitutional law, towards the protection and promotion of the human being. Three values, which are functionally connected with each other, are the basic condition of the human being. Human dignity, the fundamental freedom of the human being, which is necessarily flows from dignity, and equality as an expression of the fact that dignity and freedom are due to every human being by virtue of his or her being human. These three values also provide the basis values of a constitution. This also has an impact on the institutions of the state. The institutions must correspond to the fundamental values in their structure, in their functioning, and in their interaction, and also they must also implement these values in their activities. The rule of law is the bridge between the values part and the institutions part of the Constitution. The rule of law, therefore, has a bridging function, a function which is also necessary from the point of view of the unity of the Constitution. The rule of law is therefore value-oriented and has as its foundation the idea of constitutional primacy. The following can be said about these individual fundamental values. Human dignity is the foundation of the constitutional order of values. Man, human being, is understood as a subject, carries her value with him herself, as a philosopher Immanuel Kant says. The human being must never be made into an object, never be instrumentalized for whatever purpose. That is why human dignity is absolute, not subject to individual restriction, and it cannot be weighed against other constitutional values. The principle of freedom flows from human dignity. This principle is intrinsically linked to dignity. Without freedom, in principle, human dignity is inconceivable, and conversely, without a guarantee of human dignity, freedom means nothing. However, the principle of freedom is subject to limitations. This results from the third value, equality. It is evident that human dignity, and thus also the principle of freedom, is due to every human being as a being. That is, it must be due to all without distinction. This is the very basis for freedom restrictions. However, restrictions on freedom are only compatible with human dignity if they are necessary for a legitimate purpose. It is the principle of proportionality, now recognized as a universal principle, that indicates the boundary between freedom and restriction of freedom. However, the prerequisite for a restriction is always that there is a legitimate reason for it. Ultimately, only that reason is legitimate which is aimed at the protection and promotion of human being. An important part of freedom, political freedom, is democracy. Democracy arises from the basic idea that the individual should determine him herself as a subject and therefore in principle may not be determined by others. If public authority imposes restrictions on the freedom of the individual or essentially determines the life of the individual, this must be legitimized by the act of self-determination. The law, legislation, the most important expression of public power, of public authority, must be decided by the representatives of the individuals, the people. Through this, the self-determination of the individuals is expressed, the self-determination with regard to the restrictions on freedom. The principle of freedom is specified by fundamental rights. It should be noted that fundamental rights can also be unwritten. Constitutional law consists of written and unwritten parts. The principle of freedom requires efficient and comprehensive protection of fundamental rights. However, newly emerging dangers are also protected by the principle of freedom. This can be done through a broad interpretation of an already written fundamental right or through the interpretative visualization of new fundamental rights. The Constitution is a living instrument that continues to develop. It has an evolutionary character. If new dangers arise, there must also be sufficient protection from a constitutional protection layer. This is implicit in the principle of freedom. As consequences for the academic teaching of constitutional law, one can summarize. Constitutional law must not only be seen and taught from a national perspective. It is embedded in the international legal order and, for member states of the European Union, especially in the supranational legal order of the European Union. The transnational perspective is therefore of great importance. In addition, certain fundamental principles, namely human dignity, fundamental freedom, and equality, have universal validity, even if these values are not always sufficiently observed or sometimes not observed at all. Normatively, however, they exist, and because they relate to the human being, they also exist in general. They form a functional core of a genuine constitution. In detail, however, the perception can be different in the various systems. Comparative constitutional law will detect these differences. However, it will also take note of the fact that the order of fundamental values as such cannot be changed for the sole reason that it is connected to the essence of the human being. The purpose of my brief presentation is to highlight both aspects, the transnational dimension of national constitutional law, which is becoming increasingly important, and the general principles associated with the anthropocentric, human-centered constitutional order, should be given their due attention in academic teaching. Thank you very much.